Thank you very much for the introduction. I think I will have to take the risk of repeating some of the points which have already been made by previous speakers, and I see basically my task here to maybe go a bit more into the details of TRIPS and enforcement, what actually are the obligations and the flexibilities, the optional measures which can be adopted by countries under this agreement. Now, before I do so, I would just spend a few minutes on a sort of overview, which I think is important because nowadays sometimes we have the impression that enforcement is a sort of new issue on the agenda, but one should always bear in mind that this actually goes back decades, and counterfeiting and piracy was actually one of the issues which brought us to the Uruguay mandate to negotiate the TRIPS agreement. As we also have to bear in mind when we talk about enforcement that the TRIPS agreement is probably so far the first and only international treaty which has a detailed section with enforcement rules. Of course, you do find in some WIPO treaties, earlier and later WIPO treaties, you do find provisions on enforcement, but they are sort of isolated provisions, and there's no full set of provisions as you find them in the TRIPS agreement. Now, I think Viviana has made the tour, if you like, of organizations involved in enforcement. It's quite impressive these days. I would agree with what you said on measurement. Certainly, the OECD study at least has raised an important issue, because you do hear people say enforcement is sort of about 5 to 7% of world trade. You will hear the World Health Organization say 10% of medicines is counterfeit, with varying percentages divided in different countries, of course. But who can really tell you what is a solid basis for those figures and percentages? There's probably none at this stage, and therefore this OECD study at least has put its finger on a very important point to be further elaborated. Now, there's perhaps one organization which I would add to the list of those who are dealing these days with enforcement, and that is the World Health Organization. Why? Because there is the Rome Declaration, which goes back to, I think now, what was it, February 2006, and which has led to the establishment of IMPACT, which is an international task force to deal with, to combat counterfeit medicines. Now, this is obviously much broader than enforcement of intellectual property rights. I do sort of acknowledge this, but it also touches on aspects which are related to IPRs. So in that sense, I would just, to complete the list, I would also add the WHO here, plus of course the G8, which is focusing a lot on enforcement, and which also, I understand, is also trying to broaden actually its scope by including the BRIC countries into those action plans they are developing. And of course, bilateral regional free trade agreements, which Pedro will develop on further, so I will leave this aside. Now, what are the objectives of the TRIPS enforcement section, if we can sort of spend a moment on this? This section is about making available procedures which permit effective action against IPR infringement. And I've sort of put in italics here the making available, because that actually goes back to the preamble of the TRIPS agreement, which clearly says IPRs are private rights. So it's not up to the state, and sometimes you hear these people saying the state has to enforce. It's up to the right holder to make sure that his rights are enforced. So this making available is important in this context. And then you get into the points which I think have been mentioned at least partly already. Protection against abuse. You will find spread all over the section on IPR enforcement in the TRIPS agreement different provisions which provide for safeguards against the abuse of IPRs by right holders. So they are built into this section. We've heard that there's the stipulation in the agreement that certainly enforcement of IPRs shall not lead to any new barriers to legitimate trade. So that is a clear sort of objective at the beginning of the enforcement section. And I think the preservation of the balance between the different interests is, at least if it's not spelled out in the enforcement section, at least inherent in this section. Now, we've also heard about the application of basic principles. Yes, TRIPS is about a minimum level of protection. It's not about harmonization, as we hear sometimes. It's a minimum level of protection. But you can also opt for higher levels of protection and enforcement, of course, as long as safeguards, for example, as they are built into the TRIPS agreement and in the enforcement section, are respected. Something which I think is very dear to, or which is always coming up, at least in the TRIPS Council discussion, the freedom to determine the appropriate method of implementation. And then, as Viviana said, taking into account each member's legal system. So it's not imposing a change of legal system or practice through the establishment of multilateral rules. The non-discrimination rules and dispute settlement under the WTO do apply, and we've heard about the sort of dispute settlement cases. If I have time, I will briefly address this at the end of my presentation. And then something which I think we should bear in mind here, as regards least developed countries, obviously there is a transition period which continues to apply, the general one until 2013, and then specifically in the area of pharmaceutical products until 2016. So in other words, those countries at this stage are not obliged to enforce IPRs, especially in the area of pharmaceuticals. This enforcement has been singled out as being part of this extra transition period. There are another sort of set of principles regarding enforcement, which, as we already addressed, different legal systems are taking into account, so the difference between common and civil law systems. WTO members' resource constraints are specifically addressed at the beginning of the enforcement section, saying that there is no obligation to establish a distinct judicial system. Some, including some developing countries, have done so. That is on a voluntary basis. There's nothing which obliges them under the TRIPS agreement. There's nothing under the TRIPS agreement which shall affect members' capacity to ensure law enforcement in general. And you have this stipulation about resources. There's no obligation actually to redistribute your resources in favor of IPR enforcement, for example. There's the recognition of judicial discretion, and I will come back to this in a moment when I look into the different types of provisions in the TRIPS agreement. And of course, last but not least, we have to always bear in mind the distinction between any act of infringement and counterfeiting and piracy in particular. Now, as Viviana was saying, counterfeiting and piracy is defined in the footnote to Article 51. Well, when I say any act of infringement, for example, when you take copyright, when you're talking about cases of adaptation or substantial similarity, you would be outside the typical case of piracy as addressed by some of the enforcement provisions. So that distinction is particularly important in the context of enforcement. Now, what are the different types of provisions in the TRIPS agreement? You have mandatory provisions, and those are basically about giving the judicial or competent authorities certain powers to order measures. Now that obviously, if you say, I empower my court to do something, that implies a certain amount of discretion. And that is a typical type of provision you find throughout the enforcement section. Others are optional, where basically the agreement says members may also do something. And I've cited one example here, 51. You find many others. And the next part of my presentation is basically on those mandatory and optional provisions in the TRIPS agreement. Now, mandatory, you have those which actually apply to all types of IPR infringement. The set of general obligations, very much like those of you who studied law, this is, I guess, sort of common sense of administrative procedures which apply here, which are set up, plus civil administrative procedures and remedies. Again, some rules established here by the TRIPS agreement on evidence, on remedies, etc. Also on indemnification of the defendant. You remember I said there are also safeguards against abuse. Well, typically that would be one clause falling under this heading. I won't go into more details because the time is so short that there's not really much to say in detail about this. Then the next type of sort of mandatory provisions relates to provisional measures. So all members have to have prompt and effective provisional measures to prevent infringement and also to prevent entry into channels of commerce and to preserve evidence. There are some particular issues here, like intervening without prior notice to the defendant in audita altera parte, where appropriate. And again, you have safeguards built into this section on provisional measures such as the applicant has to provide evidence for his case. He may be asked to provide securities and even to pay compensation when he's abused his IPRs. Now then, we move away from all types of IPR infringement into specifically counterfeiting and piracy. That relates to trademark, use of identical signs on goods and pirated copyrights goods. Here we have also obligations to have border measures in place. Those are sort of mandatory for all WTO members, but only as regards trademarks and copyright. Again, there are procedures applying here, there are remedies. I will not go into those details. Counterfeiting and piracy also requires the setting up of certain criminal procedures, which are, I think Viviana mentioned this already, which are obligatory if we are talking about a willful act of trademark counterfeiting or copyright piracy on a commercial scale. The remedies are imprisonment and or monetary fines sufficient to provide a deterrent. I mean, this language already indicates also some sort of flexibility, which I will take up in the second part, which is about optional provisions and clarifications. Here we have actually for border measures and criminal procedures. Well, when we move outside the area of trademarks and copyrights, members may take measures, border measures, may make available border measures. They are not obliged to do so. Likewise, as regards exports and goods in transit, there's no obligation under the TRIPS agreement to have border measures in place, but members may do so. Parallel imports are addressed by a footnote. Again, nothing as an obligation in the TRIPS agreement. And for travelers, sorts of luggage and ex officio action, again, no obligation, but an option for members to take measures here. And then finally, criminal procedures. Again, this is left to members to decide whether beyond trademark counterfeiting and copyright piracy, they do adopt or they make available criminal procedures here to enforce IPRs. Then, I mean, these are the sort of typical points you hear when you talk about optional measures, border measures, and criminal measures for other IPRs, for example. But then if you go more carefully through the agreement, there's actually a whole range of may provisions which leave a lot of flexibility to members. And I've sort of cited some here on this slide. For example, that you can actually limit the remedies in case of use by governments or by third parties authorized by the government to pay compensation. That is something stipulated in 44.2 of the TRIPS agreement. There's some flexibility regarding, for example, recovery of profits or payment of pre-established damages, and so on. So it's quite interesting actually to see that the TRIPS agreement does contain a lot more of these may provisions than it's appearing on the surface. And then, of course, you have the sort of language which is chosen, which I've put at as the last point here under others, terminology. You have actually you will find the use of many flexible terms in the TRIPS agreement, such as reasonable, at least, sufficient, appropriate, and you can sort of continue this list for quite a while, which do imply that there is a flexibility left to members to interpret those terms and to sort of fix in their national legislation, and of course to leave it to courts also to decide on a case-by-case basis actually what sufficiently appropriate in the specific circumstances means. Then we have other, I think also important indicators for some flexibility in the agreement, and that is, for example, the principle of proportionality, which is mentioned specifically in two provisions in the enforcement section. There's the taking into account of constitutional requirements where, for example, in principle there's a measure required to be taken by a member, but then it sort of says in the second half of the sentence, as long as this is in accordance with constitutional requirements. So also there are some built-in flexibility, plus the taking into account of exceptional cases, again something which is specifically addressed in some of the provisions of the TRIPS agreement. Now that is a brief overview of what the TRIPS agreement says. We discussed, if I still have 2 or 3 minutes, very briefly on the work in the TRIPS Council. 1 minute, okay. We've heard about the review of TRIPS implementing legislation, which is done for each member at some stage. We have a specific document series which is checklist of issues on enforcement. Not every member has responded to this, but it's quite interesting to see actually at least from about 50 members, I think, who have responded how they implement the TRIPS agreement. The Article 63.3 is a more general provision that has been used by some members in an attempt to gather information, in this specific case from China, about its enforcement regime. We have heard about ad hoc discussions on enforcement in the TRIPS Council based on several communications from developed countries, so far rejected as a permanent agenda item by developing countries. And we have, last but not least, which is coming up at the TRIPS Council in 2 weeks, the transitional review under Section 18 of the China's accession protocol. Once a year, we have a sort of intensive debate on what actually China does in the area of enforcement. The TRIPS Council is not the only place, and one should bear this in mind. The trade policy review mechanism is a sort of rather soft in the sense of there's nothing really to enforce obligations or to impose any rules or so, but it is occasionally used actually to raise points which are related to IPR enforcement. So that is another forum outside the TRIPS Council where IPR enforcement related questions can pop up. And then finally, of course, the WTO dispute settlement system, and I wouldn't have much to say about the last one, which is China, because that is something I will completely stay out of the debate for understandable reasons. We cannot pronounce ourselves on this case at this stage. But I think in general it's important to remember there are only a few cases which are relevant to enforcement so far, which have been raised or which have been brought to the WTO dispute settlement in the past. Some of them are against the EU member states, basically in the area of provisional measures. They've all been subject to an amicable settlement. Argentina, Carlos knows this. I think we've been sitting in those consultations with the US at that time. I was representing the EU as a third party. Here again, provisional measures was one of the injunctions, were one of the sort of 9 or 10 points raised in here. Amicable settlement again, so no ruling from the WTO. And then you have 2 panel reports which do address enforcement, but again only marginally. Interestingly, perhaps the first one, the US Section 211 case, which did say very clearly that even a presumptive trademark owner has rights under Article 42, and so that was an interesting stipulation for this specific provision of the enforcement section. With that, I think I come to the end of my presentation. I would just have one remark in response to what I heard at the opening session this morning. I think it's certainly absolutely sort of relevant to talk about a development-friendly enforcement agenda. However, what I've heard this morning, I would think are more typically substantive items, such as protection of traditional knowledge, genetic resources, transfer of technology. Those are in the first place related to establishing substantive rights and obligations, and then as a secondary item, I guess you come to the point at some stage, how do I enforce those rights and obligations? But I was a bit sort of puzzled when I heard this being part of a development-friendly enforcement agenda, because I think the first step is first to get to establishing those rights, and then we can talk about enforcing them as a second point. With that, I come to the end of my presentation. Sorry for rushing through this, but I will be here for the rest of the day, so I'm also happy to talk to you during the breaks. Thank you.
Thank you, Mr. Rosenkamp. I completely agree with you that for such subject we need more time. That will give us this very